Welcome back to Power Corrupts Again, the show that covers judicial and other government corruption. We're going to be interviewing some people today on their stories, mostly in the Detroit area, but really from all over Michigan. And we want to welcome you. We've got different guests. Some are going to be wanting to speak anonymously. Some are going to be very candid about their stories. So here is our first guest, and I will not mention a name on this one.
The intent of this testimony is to inform the U.S. House and Senate, as well as our fellow Americans. The following information is from public records, news articles, transcripts, Judicial Tenure Commission, or attorney discipline complaints. I am the victim of legal abuse. I am you. In 2012, the Center for Public Integrity ranked Michigan 43 out of 50 in their state corruption report. Michigan was given an overall grade of F, as well as an F in judicial accountability. Michigan was only one of 5 states to receive an F in judicial accountability. The incestuous legal industry cartel protects their own. Selectively, the Oakland County Courthouse allows only attorneys, not the public, to bring recording devices into this public building. This gives the appearance that there's something to hide. I have received edited official transcripts. I was sued by a builder for breach of contract for not closing on a home with major, unlawful construction code defects. It appears this theory of liability was created so the court could be used to transfer my property rights to the builder so he could sell the defective home for greater than $100,000 more than my contract. The judge and my attorney both paid off mortgages and purchased new real estate, commencing the day I was put in a room with another judge who, in his robe, said, "Anarchy, and don't let a third party determine your fate." There was a Michigan insurance company involved in this case. The attorney for the insurance company gave my check to my attorney, who proceeded to deposit this $25,000 check into his account without my endorsement. In other words, he embezzled my check. Per the public record, there is prima facie evidence of bribes from the Michigan insurance company to the judge and the attorney, as they both paid off mortgages and purchased new real estate without selling their residences within the same 21 days. During the course of events, I was ordered to pay another judge $1,800 to supervise the settlement. While there was a pending motion to disqualify the judge which stayed the case, a secret, hidden, never served order was entered into the record giving my attorney rights to the $25,000 check plus an additional $182,000 worth of liens on my property for attorney fees he didn't earn. When I am post-mortem, the judge and the attorney can be post-haste. The appeal of this case closely went to then Justice, now Prosecutor Jessica Hooper, with whom both the attorney and the judge worked. The appeal was denied. I connected with another lady scammed by the same attorney and bricklayer. We discovered our common attorney was also representing the bricklayer. When this attorney found out that we connected, he obtained a personal protection order against her, prohibiting us from associating, including forbidding us from going to church or court together, even when the attorney was not present. This attorney had the other lady jailed twice for a total of 8 days when she appeared in court with me. Both the Attorney Grievance Commission and the Judicial Tenure Commissions were contacted. The AGC refused to investigate, and the JTC found no wrongdoing. With all these cases evolving, there was a death in my family. And that attorney erroneously put a home with a viable quitclaim deed into probate, caused numerous extensions, and created legal documents with errors which were rejected by the Register of Deeds and the Assessor's Office. A grievance was filed, and then this attorney obtained a court order for an additional $1,300 in attorney fees. I was then approached saying they would not enter this order for an additional $1,300 if I would agree to dismiss the AGC complaint. I said my integrity could not be bought and paid the additional $1,300. Then there was a legal malpractice case. This judge allowed discovery to be reopened to subpoena my teacher work records, which were irrelevant to legal malpractice and could be obtained under the Freedom of Information Act. Then this judge dismissed the malpractice suit when the notice of hearing was not sent to me. Then I was sued for defamation when someone posted an anonymous comment on the lawyer rating site. There was no proof that I posted the comment, there was no notice as to when or where the comment was posted, and there was no reasonable time to retract. Cozily, the same attorney had another defamation case in the same judge's court at the same time, which was dismissed, relying on the First Amendment. But in my case, the same judge denied due process, ordered my insurance adjuster to be present at a facilitation in another county, which I endured for 8.5 hours from 5 p.m. until 1:30 a.m. the next morning. This attorney trespassed on my property and served legal documents by sticking them in a door in an unsecured location. They made out like bandits for legal abuse with a strategic lawsuit against public participation as fraud on the court and a fishing expedition for a defamation case without proof and without reasonable notice. The intent of this lawsuit was to forbid me from telling the truth about an attorney and to create a fear about telling the truth. When I reviewed the settlement document prior to signing, I insisted must prove be included in the wording, but I signed only the last page. After returning home, I noticed that must prove was removed from the document I was given. Then I was hauled into court for contempt for filing attorney grievances for perjury and fraud on the court. The attorney, now provided by the insurance company, committed perjury by denying that the words must prove were eliminated on the settlement document. However, I had 2 copies of the draft with must prove noted. If this attorney were correct, she was admitting I had ineffective legal counsel. The last 2 transcripts are inaccurate records of the hearings, as there were observers who recalled the events in the same manner I recall. The settlement document states that I cannot tell the truth about an officer of the court. I was forbidden from speaking at any more Michigan Supreme Court public hearings. The Attorney Grievance Commission refused to investigate this legal abuse and responded, quote, "You should bring your concerns to the attention of the trial judge, who totally enabled the legal abuse to benefit the attorney's revenue stream. Rhetorically, how can attorneys make out like bandits when they failed in their burden of proof, did not prevail at any motion, and were non-compliant with statutory and decisional law as well as court rules? Again, neither the JTC nor the AGC found any wrongdoing."
Now, you said that you were a teacher. You have some credibility. You've gone through background checks. Where did these events occur?
In Oakland and Macomb counties in Michigan.
And were the judges aware of the attorney's behavior and vice versa?
Oh, yes, they enabled it, absolutely.
And regarding the embezzled checks and the bribes, did you report these? And
yes, I've been to the FBI, the U.S. Attorney's Office, prosecutors in Oakland and Macomb County, the Attorney Grievance Commission, the Judicial Tenure Commission. The records were made in other court cases, so other judges were aware of what was going on with these cases.
So we have a self-policing environment where nobody's doing their job.
Yes, it's
everybody's looking the other way. We've got. You said you've been to the FBI, so the U.S. Attorney. Did you hit
Yep.
there? These are places that I've been. By the way, we got to look at the patterns here. You've been to the Attorney Grievance Commission.
Yep.
The Judicial Tenure Commission.
Yep.
I know I've been to each of those places. Of course, they say either that they won't investigate, or that they've investigated and found no violation. Where else did you say?
The prosecutors in both Oakland and Macomb County.
Jessica Cooper in Oakland County. I've been there. Macomb County. I probably have the same story in Wayne County.
Okay.
In Washtenaw County. So we've got a whole region here in southeast Michigan that is self-policing. It's supposed to be monitoring. You've been to other judges. So every time you take it to either to a higher level judge, their responsibility is to be looking at what the lower level judge did, and they are being malfeasant in that duty. Is there any of this information that's available online?
Yes, there's a YouTube channel and rip-off reports. If you go to Google Sister Mary Litigation as one word, those reports will come up.
Sister Mary Litigation. Okay. Is there a .com or anything?
No, just ripoffreports.com or youtube.com, and my channels are Sister Mary Litigation, one word.
Got it. Is there anything else that you'd like to add to this
Well, I understand the public record documents are going to be scanned and available online. The email that I had to pay a judge $1,800. The fact that the one attorney actually subpoenaed my emails going back to 2007 secretly, and it was only that my email provider told me about the secret subpoena, that he wanted all my emails of who I was sending emails to, who I was receiving emails from, going back to 2007, which was totally irrelevant to something on the internet posted anonymously by somebody else in 2009. There's a lot of underhanded stuff going on with this.
Well, and it's very interesting that whenever we want to make an allegation or a complaint or anything like this, that we have to open ourselves up entirely. Mm-hmm. There is no bars pulled. You know, there are no holds that are barred in taking exploration or discovery of anything that we have in our possession, in our past, anything like that. But when we try to get anything out of the government, they will claim immunity. They will claim that it's irrelevant, that we're frivolous filers, all this other kind of stuff that prevents us from getting anywhere. And these judges, over and over and over again, are dismissing our complaints. Are just, it's almost a copy paste. If the government is defending themselves with certain statements, then they will, the judge's clerk will just do a copy from those statements and put it right into the ruling and publish it, and these are fraudulent statements. You know, so you are talking felony fraud on the court and the public. Well, we thank you very much for coming in.
Thank you.
And I know that we all have to deal with the aftermath of this, and on a number of levels, emotionally, financially, everything else. And I want to tell you how grateful I am that you've got the courage to come in and speak on.
Well, I appreciate the opportunity and the fact that it's helped me network with others who have the same story, different players, but the same story over and over and over and over again.
Same patterns, yeah. And sometimes the same players.
Oh yeah, the same players. In my case, in the other lady's case, it was the same attorney representing both of us and also representing the culprit in our cases. Now, how incestuous is that?
Now, you had a same judge as somebody else too.
Oh yeah, yeah. If you go to the YouTube, you will see an interesting PPO hearing without a case, without an order, and I was told to pay the clerk $500 with no case and no order.
Thank you very much.
You're welcome.